book? Not one single one.
Good morning, this is Dalia Romero, Spanish interpreter on the line, already sworn in today.
Good morning, Ms. Romero. This is Judge Bain calling from the BRC.
Good morning, Your Honor. I've made a connection to the podium, Your Honor.
Let's see if we can make sure you can hear you.
Yes. Buenos días, señor. ¿Puede?
Sí.
He can hear the interpreter, Your Honor.
Give me 1 second here. Good morning, sir. Can you tell me your name?
Luis Felipe Serrano Bonilla. Luis Felipe Serrano Bonilla.
Luis Felipe Serrano Molilla.
Good morning, sir. You're here in an Osceola County case 2020 CF 527AO for a warrant issued out of Osceola County. The judge in Osceola County set your bond at no bond as his violation of probation case. Your bonds can remain at no bond. I want to appoint the public defender to represent you in this matter. You have a great day, sir.
Con permiso, pues me gustaría saber porque no entiendo nada, ¿me entiendes? Yo estaba en mi casa lo más normal.
Excuse me, but I would like to know because I don't understand. I was at my house just like normal.
Y ayer mismo yo hablé con el oficial probatorio, él me iba a ver la casa, llevarme un papel y nunca fue.
And yesterday I spoke to my probation officer and he told me he was going to bring some paper to my house, but he never came over.
I'm not sure what the violation entails. I don't have the actual warrant. So you got to speak to the judge in Osceola County tomorrow. Have a great day.
Gracias.
Thank you. Is that the only case we have for the interpreter, Your Honor?
Yes, ma'am. You have a great weekend.
Thank you. You do the same.
Good morning, sir. Can you tell me your name? Mr. Baker, you're here in case 2021 CF 11674AO on a charge of tampering with a witness and hinder communication and battery domestic violence. I did review the charging affidavit in your case. I did find probable cause for your arrest. I'm going to set your bond in count 1 in amount of $2,000, count 2 $500. Condition of your bond is that you had no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at the shared residence. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. And I'm going to appoint the public defender to represent you in this case. Do you have any questions about your no contact order, sir?
No, sir.
All right, have a great day, sir. Good morning, ma'am. Can you tell me your name?
My name is Carol LaChonda Cobb.
Ms. Cobb, you're here in case 2021 CF 11654AO on 2 counts of aggravated battery with a deadly weapon, domestic violence, and 1 count of criminal mischief. I did review the charging affidavit in your case. I did find probable cause for your arrest. I'm going to appoint the public defender to represent you. I'm going to set your bond in count 1 in amount of $1,000, count 2 $1,000, and count 3 $500. Condition of your bond to be subject to pretrial release supervision. You to have no contact with the victim in this case. You are to maintain a separate residence from these victims. I'll give you a one-time return with law enforcement to retrieve any items you have at a shared residence. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this matter. If you have a question, I'm going to have you ask Mr. Brands, because everything you ask me is on the record, can be used against you.
That's fine.
you one moment, sir. All right, sir, can you tell me your name?
My name's Yasser Robbie Patel.
Mr. Patel, you're here in case 2021 CF 11661AO on charge of aggravated assault, domestic violence, and battery domestic violence. I reviewed the charging affidavit in this case. I did find probable cause for your arrest. Ms. Davis, he would qualify, right? So you refuse to talk to the people from pretrial release services?
I refuse to talk to who?
The people from pretrial release services, they called you up to a window downstairs?
No, I didn't refuse to anyone. No one called me or anything like that. No one talked to me or anything like that. I just got arrested yesterday.
Yeah, I know that.
And yeah, I was at my sister's place.
Well, don't talk about the facts of your case. I'm trying to figure out what happened downstairs when you're being processed through the jail.
No one talked to me or anything. I didn't refuse anything.
Put your mask over your nose. That's what she's trying to tell you.
I didn't refuse anything. I was in the hospital yesterday.
Other than that, will you qualify, Ms. Davis? All right, sir, I'm going to set your bond to count one, amount of $1,000, count two, $500. You'll be subject to pretrial release supervision. You'd have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. And I'm going to appoint the public defender to represent you in this matter. Do you have any questions about your no contact order?
Yes, sir, I have. Sir, about the bond.
No, no contact order. Answer my question.
Yeah, no contact order, no problem.
All right.
It's just about the bonds that my car has been stolen about 6 months ago, and about 2 weeks ago, I have also incident report with the sheriff's office that my stuff and my telephone, everything has been stolen.
Okay.
And I'm currently here by myself, so I'm currently, and plus, before yesterday, I had court for my license. I'm supposed to get my license back so I could sit down and go to work and stuff like that. But currently, I don't have enough money to do the bonds. There's no way that you could cancel the bonds because yesterday.
No, sir. You're charged with a dangerous offense under our statutes, and I cannot release you on non-monetary release. So you have a great day, sir.
So I would have to pay $100 for the $1,000 bond, and then I would have to pay $50.
You got to work that out with the bondsman or whoever's going to post your bond.
$100.
Good morning, sir. Can you tell me your name?
R.S. Paul.
Mr. Paul, you're here in case 2021 CF 11605AO on charge of battery, domestic violence by strangulation. I did review the charging affidavit in your case. I did find probable cause for your arrest. State, can you tell me these prior domestic violence cases? Well, hello. Maybe we'll find out right now. Good morning, ma'am. Can you tell me your name?
I'm Tiffany Paul.
Ms. Paul, can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Put your hand down. Ma'am, can you tell me how you know Mr. Paul?
He's my husband.
And do you want to have contact with your husband while this case is pending?
Yes.
Has there been previous instances of domestic violence between you all in the past?
No.
So are you the subject of these prior to domestic violence arrests?
No.
There are two different victims, Your Honor.
Are you aware of this domestic violence history?
I am aware of that, yes.
Knowing that, you still want to have contact with Mr. Paul?
Yes, because since then, he's scheduled for anger management.
Yeah, so that's, I'll tell you right now, that's gonna be a waste of your time.
Okay,
All right? Well, other questions. Did drugs and alcohol play a role in this incident?
no,
All right? If he wants to go to counseling, you try a batterers intervention course. Anger management has nothing to do with batterers. All right? That just makes them better at batterers.
okay,
Doesn't help. All right?
yes,
So Mr. Paul wants to do that, then he can enroll himself in a batterers intervention course. If not, then it's up to him.
okay.
All right. Say, you got any questions for the witness?
I do not, Your Honor.
Mr. Brantz?
No questions, Your Honor.
Mr. Paul, I'm going to set your bond in this case in the amount of $2,500. It's going to be subject to pretrial release supervision. You'd have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. And I'm going to appoint the public defender to represent you in this matter. You have any questions about your no contact order, sir?
No. I have to pay $2,500 in order to leave this facility.
You can pay the full amount, or you can work with a bondsman, it's up to you, and pay their fees. However you'd like to choose to bond out is up to you. All right, have a great day, sir. Answer their own questions. All right, good morning, sir. Can you tell me your name? You got to slide a little bit over to the, right in front of the mic. Thank you, appreciate that.
Vicente Pilcher.
Mr. Peak, you're here in case 2021 CF 8280 AO on a warrant signed by Judge Bleckman revoking your bond in that case. Your bond is now set at $0. Your bond is going to remain at $0 until you guys have a conversation with Judge Bleckman. I believe the public defender is already appointed in your case. You already have an attorney, or you have the public defender, correct?
Public defender, that is correct.
All right. All right, have a great day, sir. Good morning, sir. Can you tell me your name?
Terrell.
There you go. Mr. Terrell, you're here in case 2021 CF 11612 AO on charge of aggravated assault with a motor vehicle and stalking domestic violence. Did review the charging affidavit in your case, did find probable cause for your arrest. Going to set your bond in count 1 in an amount of $3,000, count 2 in an amount of $1,000. You'll be subject to pretrial release supervision. You have no contact with the victim in this case. You're not to return to the scene of the location where this incident happened. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. And you may not possess or consume any drugs or alcohol while you're out on release in this case. You'll be subject to random drug and alcohol testing through pretrial release. I'm going to appoint the public defender in this case to represent you. Do you have any questions about the no contact order?
No, I do not, Your Honor.
All right, have a great day, sir.
Thank you. Good morning, ma'am. Can you tell me your name?
Layla Thurman.
Ms. Thurman, you're here in case 2021 CF 11655 AO on charge of aggravated assault domestic violence, aggravated assault with a deadly weapon domestic violence and battery domestic violence. Did review the charging affidavit in your case. It did find probable cause for your arrest. Going to set your bond in count 1 in the amount of $1,000, count 2 $500. It's going to be subject to pretrial release supervision. You have no contact with the victim in this case. You are to maintain a separate residence from this victim.
Okay.
I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. And I'm going to appoint the public defender to represent you in this matter. Do you have any questions about the no contact order?
So what do I do when I leave here?
So no contact. You
This
can
is
work
like
with
my first
pretrial
time.
release. If you can call law enforcement, if you need to go over there and pick up your stuff.
I have to call law enforcement, pick
Yep.
up my stuff?
Yep.
Okay.
Don't go there without law enforcement. Go there without law enforcement, you're going to be arrested, okay?
Oh, to the to the residence?
Yes.
Oh, okay, okay. I thought you meant I have to call the law enforcement.
Yeah, so you have to go with them.
Okay, I meant like for here.
No. You're gonna leave, like, you'll be just, like, bond out here. When you
Okay.
post bond,
I
then,
was told there was no bond.
yeah, I gave you a bond.
Oh, okay, that's what that means. Okay, okay.
Yeah,
Sorry,
no
first
problem.
time.
No problem.
Okay.
All right, have a great day, ma'am. Good morning, ma'am. Can you tell me your name?
Good morning, Pamela Bain.
Ms. Bain, you're here in case 2021 MM 385AA on charge of battery domestic violence. Did review the charging affidavit in this case, did find probable cause for your arrest. Sir, can you tell me your name and spell your last name?
Sure. Mohammed, Mohammed.
All right, can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You put your hand down. Can you tell me how you know Ms. Bain?
She is my wife.
Are you all legally married?
Yes.
And do you want to have contact with her while this case is pending?
No.
Has there been previous instances of domestic violence between you all in the past?
Sorry?
Has there been previous instances of domestic violence between you all in the past?
Yes.
When was the most recent one before this time?
She come nervous without any reason.
No,
And she
when?
Sorry?
Answer my question. When was the most recent one before this incident that she was arrested for?
Sorry, again?
When was
Sorry,
the-
my English
Yes,
is not
ma'am.
perfect.
I was just going to make note that Mr. Muhammad, his first language is Arabic. He does understand English, but possibly if you slowed down, he may be able to comprehend better.
Do you want the services of an Arabic interpreter?
No.
When was the last time that you all were involved in a domestic violence incident?
Yesterday. But you mean before
that time?
yesterday?
Yes.
Yeah, we start even last week. She also shouting, but nothing serious happened.
All right. Were you the victim in this prior aggravated battery domestic violence case from 2015?
No.
All right. Were you aware of that case?
No, I joined USA in 2019, November.
All right. Knowing about her prior domestic violence history, do you want to have contact with her still?
Sorry, again?
Knowing about her prior case, do you still want to have contact with her?
I don't know about the old case.
All right.
I don't have any information.
Okay. Did drugs or alcohol play a role in this incident?
Before this happened, before night.
All right.
Yeah. We was in restaurant and she drank.
State, do you have any questions for the witness?
No, Your Honor.
Mr. Brandt, do you have any questions for the witness?
No questions, Your Honor.
Does anybody want to advocate for anything other than no contact?
No.
All right. Ms. Bain, in this case, we're going to set your bond amount of $500. It's going to come with pretrial release
Excuse me?
supervision. You'd have no contact with Mr. Muhammad. You are to maintain a separate residence from him. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You also may not possess or consume any drugs or alcohol without a valid prescription. You'll be subject to random drug and alcohol testing while you're out on release in this case. I'm going to appoint the public defender to represent you in this matter. You have any questions about your no contact order, ma'am?
No, Your Honor.
All right. You have a great day, ma'am. All right. Good morning, sir. Can you tell me your name? Hello.
Kevin Brumman.
I'm over here. There you go. Good morning. Can you tell me your name?
Kevin Brumman.
Sir, you're here in case 2021 MM 6055 AO on charge of battery dating violence. Did review the charging affidavit in this case. Did find probable cause for your arrest. State or Ms. Davis, were these prior cases involving the same victim?
The ones in Orange County were not, Your Honor.
All right. Orange, different includes the kind of. There's one from 2019, maybe? The rest of them are different victims. All right. Mr. Berman, you're going to set your bond in this case in the amount of $2,000, conditioning your bond that you have no contact with the victim in this case. You maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess or consume any drugs or alcohol without a valid prescription. You subject to random drug and alcohol testing. You need to turn over any weapons or firearms you have to law enforcement within 24 hours of your release because you're not allowed to possess any. Mr. Bradley, based on your criminal history, I don't know if any of these other cases you had the opportunity to enroll in a batter's intervention course, but you may want to try
They
one.
all got dropped, Your Honor. It was all dismissed.
Do you want to keep getting arrested for similar instances?
No.
So if you don't want to get arrested anymore, because obviously something continues to happen with multiple people, not just the same person.
I'm getting with the wrong woman is what it is, Your Honor.
Yeah, so just for your benefit, you may want to enroll in one of those courses. It may give you some tools to de-escalate situations and prevent you from law enforcement being called in the first place.
Yeah.
Just thoughts. I'm not ordering you to do it, just, considerations you may want to think about. All right, have a great day.
All right, you too.
All right, good morning, sir. Can you tell me your name?
Good morning, Cabrera Manuel Jr.
Say your name again.
Cabrera Manuel Jr.
Mr. Cabrera, you're here in case 2021 MM 6046 AO on charge of battery, dating, violence. Did review the charging affidavit in your case. Did find probable cause for your arrest. Going to set your bond in this case in the amount of $1,000. Condition your bond. You have no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess or any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You also may not possess any drugs or alcohol without a valid prescription. You're subject to random drug and alcohol testing at your expense. Going to appoint the public defender to represent you in this matter. You have a great day, sir. Good morning, sir. Can you tell me your name?
Morning, DeAndre Caldwood.
Mr. Caldwood, you're here in case 2021 MM 6042 AO on charge of battery, domestic violence. Did review the charging affidavit in your case. Did find probable cause for your arrest. Going to set your bond. Oh, sorry. Good morning, ma'am. Can you tell me your name?
Janique Gashard Caldwood.
Can you spell your last name?
GUISHARDCALLWOOD.
All right. Can you raise your right hand to be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, put your hand down. Ma'am, can you tell me how you know Mr. Caldwood?
He is my ex-husband.
Mm-hmm. And do you want to have contact with your ex-husband while this case is pending?
No, thank you.
All right. Did drugs or alcohol play a role in this current incident between you all?
No, it doesn't.
All right. Do you all have children in common?
No.
All right. Mr. Caldwood, I'm going to set your bond in this case amount $250. It's going to come with pretrial release supervision. You have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items. Does he have anything at your house?
Yes.
Give you one-time return with law enforcement to retrieve any personal items that you have at her residence. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. Do you have any questions about your no contact order?
I have a bunch of furniture there.
Do you have any questions about the no contact order?
No.
All right. So you get one-time return with law enforcement. Go get your stuff. Don't go there without law enforcement because you're gonna get arrested. You gotta go with law enforcement to get whatever you need. Now, if you plan that you're gonna move like furniture and TVs and stuff like that, it's probably not gonna happen because the law officers doesn't have time to sit there and wait with you while they had to go to other calls. So you gotta go in there, get your stuff, and go. Got it?
Okay. Can I ask a
All right,
question?
I'm going to appoint the public defender to represent you, so you're going to have ask Mr. Branch a question because I don't want you to ask me a question that's going to incriminate you. Have a great day, sir. Have a great day, ma'am.
Thank you.
Good morning, ma'am. Can you tell me your name?
Good morning, my name is Shika.
Say your name again.
My name is Shika Galagos.
All right, ma'am, you're here in case 2021 MM 6025 AO on charge of battery domestic violence. Did review the charging affidavit in your case, did find probable cause for your arrest. Going to set your bond in this matter, amount of $250. Is going to be subject to pretrial release supervision. You may not possess, so you may not come in contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. The weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. You may not possess or consume any drugs or alcohol without a valid prescription. You're subject to random drug and alcohol testing at your expense. I'm going to appoint the public defender to represent you in this matter. Do you have any questions about your no contact order?
No, sir.
All right. You have a great day, ma'am. Good morning, ma'am. Can you tell me your name?
Grenisha Harp.
I can't hear you.
Grenisha Harp.
Ms. Harp, you're here in case 2021 MM 558 AW on charge of stalking. Did review the charging affidavit in your case, did find probable cause for your arrest. All right, this wasn't charged as a domestic violence incident. So the court's going to release you on pretrial release in this case. Conditions of your pretrial release is that you are to not have any contact with the victim in this case. You need to make sure you're maintaining a separate residence from this victim, okay? No weapons, no firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. Do you have any questions about the no contact order?
No, I don't.
All right.
Your Honor?
I want to appoint the public defender. Yes, ma'am.
Could you also ask for her not to be within 1,000 feet of his work or residence?
No, this isn't a no contact order. It's a no contact order. No within 500 feet of the place of like his work. No over 500 feet of the place of residence. No over 500 feet of the vehicle. All those stipulations. No social media contact. No third party contact. No carrier pigeons. No writing letters in the sky. No billboards. Nothing. Zero contact. You understand?
I do.
All right.
Your Honor, will be appointed as well.
Yep, I did appoint a public defender to represent you. Please do not violate my orders. All right? Right there. Good morning, ma'am. Can you tell me your name?
Ita.
Ma'am, you're here in case 2021 MM 6051 AO on charge of battery domestic violence. Did review the charging affidavit in your case. Did find probable cause for your arrest. Good morning, sir. Can you tell me your name and spell your last name?
Andrew Kishan, K-I-S-H-U-N.
You had to come a little closer to the mic. There you go.
Andrew Kishan,
All right.
K-I-S-H-U-N.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You can put your hand down. Sir, can you tell me how you know, ma'am, how you say your last name again?
Left and right.
Like Ryan. Can you tell me how you know the defendant, ma'am?
Sorry?
Can you tell me how you know the defendant?
She's my fiancée.
And do you want to have contact with her while this case is pending?
Yes.
Has there been previous instances of domestic violence between you all in the past?
No.
Did drugs and alcohol play a role in this incident?
No.
Do you have any questions for the witness?
No, Your Honor.
And Mr. Brands?
No questions, Your Honor.
Anybody want to advocate for any position?
I don't believe she has a very elaborate criminal history of any Would you qualify for pretrial release?
So that's the next question I have. Ms. Davis. Since she wasn't interviewed, would she qualify?
Oh, yes, she qualified.
All right. All right, man, I'm gonna set your bond in this case amount of $250. You're gonna come with pretrial release supervision. I'm gonna order you to have no hostile contact with your husband. Look at me. Hello.
Fiancé.
No, you need me to focus on me right now. All right? You, like, just laser in on me right now for a second, okay? You have no hostile contact. No hostile contact means this. You can have arguments with your fiance. You can be upset that he's not treating you in the way that you want to be treated, not cleaning up behind himself, leaving the toilet seat up when he goes to the restroom. All those things that cause conflict in a marriage or in a relationship are okay. However, those disagreements cannot turn violent. They cannot turn threatening. There can be no abusive language used, because no matter whether he calls law enforcement or somebody that sees or hears you all arguing calls law enforcement, you will be arrested. You're spending the remaining of your time here with me at the Orange County Jail. Do you understand that? I can't hear you.
Yes.
All right. You also may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm also going to appoint the public defender to represent you in this matter. You have a great day, ma'am.
Sir,
Yes, sir.
I would like to request that I take my personal belongings from her home. I would go with the.
Well, I ordered that she have no hostile contact with you, so you're able to talk to each other and get your stuff, do whatever you want to do. If you don't want to be with her anymore, then that's something that you guys can work out.
Okay.
But I didn't prohibit her from having contact with you.
Okay. Yeah.
All right. Have a great day.
Thank you.
Good morning, sir. Can you tell me your name?
Rafael Rincon Jr.
Mr. Rincon, you're here in case 2021 MM 6047 AO on charge of battery dating violence. Did review the charging affidavit in this case. Did find probable cause for your arrest. I see a lot of cases. Are any of these all involved in the same?
Yes, we've been together 25 I'm sorry.
Talking to the state of Florida.
Yeah. One moment, Your Honor. Your Honor, sometimes it's his wife and sometimes it's his son.
All right, Mr. Rickon, in your case, I want to set your bond at an amount of $2,500. Condition of your bond, you had no contact with the victim or the victim's family. You are to maintain a separate residence from these victims. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. The weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. And I'm going to appoint the public defender to represent you in this matter.
Your Honor, as to his out on bond, would you consider revoking and setting at a higher monetary amount?
Oh, I'm sorry. I've got one more thing before we get to that part. As to the 2000 battery case, no drugs or alcohol without a valid prescription, subject to random drug and alcohol testing. Sorry, now go Mr. Brands.
As to his out on bond case, would you consider revoking and setting at a higher monetary amount? As it is a traffic and drug possession as opposed to a violent harm to person?
The alleged facts in this affidavit, if I remember correctly, is that Mr. Rickon has a substance abuse issue that he has either been struggling with or been denying. He also has a mental health condition that he, wants to mix his alcohol with his alcohol and drugs with that medication, which don't go together. Because it seems like you are maybe suffering from a bipolar depression disorder. I don't know, based on the affidavit I read. So the medications for that disorder do not mix at all with any other narcotics, any other substance. You mix those two, you're going to get arrested. It's almost guaranteed. Yeah. All right. Well, no problem. We're all thinking this. Also, the problem is you're on probation in one of those cases. That's really the issue. I'm really more reason why I'm not going to give you another bond. Because in 2020 CT 4404 AO, you're on probation in that case. Of course, we're going to find revoke the bond in that case, find probable cause to commit a new law offense as part of your release conditions on your probation. You're also out on bond in case 2021 CF 7046 AO. Of course, we're going to revoke that bond, set that bond at none in both cases. You got a public defender representing you in all your cases, I believe. Not today. You gotta go talk to your division judges about what release conditions they feel comfortable releasing you out on at this point.
They'll take you to court.
Yep, you'll still be at your court date on Monday. We'll make sure you get there.
Is there anything you can do, Your Honor?
No, sir. At this point, I'm not sure there's any reasonable conditions I can release you out on that's gonna keep you from getting in trouble at this point. All right, have a great day. All right, ma'am, cover your nose for me. Thank you kindly. Good morning, sir. Can you tell me your name?
My name's Ryan Stalvey.
Sir, you're here in case 2021 MM 6057 AO on charge of battery domestic violence. I did review the charging affidavit in your case, did find probable cause for your arrest. Good morning, ma'am. Hello. Can you tell me your name and spell your last name?
Caitlin Crawford, CRAWFORD.
All right. And can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. Can you tell me how you know Mr. Is it Stout? Say it again.
Stalvey.
Stalvey, Mr. Stalvey.
He is my little brother.
Okay. And do you want to have contact with your little brother while this case is pending?
Yes, I'm also trying to drop the charges.
Well, today is not the day for that. So.
I know.
All right. And has there been previous instances other than you guys are growing up, domestic violence between you all in the past?
I mean, we fight like brother and sister. I do want to put it out that this week does mark a year since we lost our mom. We are both been on edge, and we're both grieving. We're both still angry about everything, and we kind of both lost it.
Okay. Well, one, cover your nose.
Sorry.
Two, you all are no longer little kids.
No.
You can fight like brothers and sisters when you're little kids. Like, I have two toddlers.
Yeah.
They're like oil and water or like peas and carrots. It's either one of the two. So, this is what happens. But when you become an adult,
can't get into fights anymore.
Kind of stop doing that. All right. Did drugs or alcohol play a role in this incident?
No, sir.
All right. State, do you have any questions for the witness?
No, Your Honor.
And Mr. Brands?
No questions, Your Honor.
Does anybody want to advocate for any position?
No, Your Honor.
Your Honor, he does qualify for pretrial release. He does not appear to have any violent offenses. I have no objection to pretrial release.
All right. All right, sir, we're going to set your bond in this case by $250. It's going to cover pretrial release supervision. You had no hostile contact with your sister. Now, I want to explain to you this. No hostile contact means this. You can have arguments with your sister. Like I said, siblings disagree. It's part of the deal when you have somebody that you grew up with, that you're close with, okay? However, those disagreements cannot turn violent. They cannot turn threatening. There can be no abusive language used. Because no matter whether your sister calls law enforcement or somebody that sees or hears you all arguing and calls law enforcement, you will be arrested. You're spending the remaining of your time here with me at the Orange County Jail on a no bond status. You understand that?
Yes, sir.
You don't have to possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this matter. You have a great day, sir. You have a great day, ma'am. Good morning, sir. Can you tell me your name? You got to slide in front of the mic for me. There we go. Appreciate it.
Case
Thank you.
Office J. Thompson.
Mr. Thompson, you're here in case 2021 MM6041AO on charge of battery, dating, violence. Did review the charging affidavit in your case, did find probable cause for your arrest. Good morning, ma'am. Can you tell me your name and spell your last name?
My name is Hugh Ann Brown, Brown.
All right. Can you raise your right hand? You solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right. Put your hand down, ma'am. Can you tell me how you know Mr. Thompson?
He's my boyfriend and the father to my soon-to-be 5-month-old daughter, Carolina.
Okay. And do you want to have contact with him while this case is pending?
Yes, Your Honor. And if I may speak,
1 second. Let me get through these questions, and then I'll give you a chance to talk, okay? Has there been previous instances of domestic violence between you all in the past?
No, Your Honor.
Did drugs or alcohol play a role in this incident?
No, Your Honor.
Tate, do you have any questions for the witness?
I just want to
wait. Let me get the state of Florida. You have any questions for the witness?
no, Your Honor.
No, Your Honor.
All right, Mr. Brantz. All right, there you go. Now it's your turn.
I just wanted to state that the incident and how everything happened, it wasn't his fault per se, because we were financially and stuff, we were both frustrated and trying to sort things out, and the argument got heated between both of us, and it spiraled out of control. But nothing has ever happened before. When we have arguments and stuff, we were always able to sit and talk things over.
All right. Does anybody want to advocate for any position?
Excuse me?
Brantz?
This time, Your Honor, no.
Hey.
Again, Your Honor, he does qualify for pretrial release. He has absolutely no history, and in light of the victim's testimony, I have no objection to pretrial release.
All right, Mr. Thompson, we're going to set your bond in this case amount $250. It's going to cover pretrial release supervision. You have no hostile contact with Ms. Brown. Now, I'm going to explain to you what that means. No hostile contact means this. Ms. Brown, you and Ms. Brown can have arguments about your financial situation, about how to take care and raise your children. Those arguments are natural. You have arguments about whether you're treating her properly, or whether you are doing something that's not going to be consistent with a healthy relationship. Those are disagreements that are okay. However, those disagreements cannot turn violent. They cannot turn threatening. There can be no abusive language used. Because no matter whether Ms. Brown calls law enforcement, or whether somebody that sees or hears you all arguing calls law enforcement, you will be arrested. You're spending your remaining time here with me at the Orange County Jail on no bond status. You understand that?
Yes, Your Honor.
You also may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you in this matter. You have a great day, sir.
Your Honor, I'm sorry, would I be able to take care of everything downstairs?
I believe so.
Thank you.
Your Honor,
Yes, ma'am.
DCF was also contacted, so can you ask that they comply with DCF orders?
If there is a DCF case plan open, then, or he comply. Good morning, sir. Can you tell me your name?
My name is Samuel Williams.
Mr. Williams, you're here in case 2021 MM 6040 AO on a charge of violation of a domestic violence injunction.
Yes, sir.
1 second here. And you're also here in 2021 CT 5956 AO on a charge of driver license suspended.
Yes, sir.
You review both those charging affidavits, did find probable cause for your arrest in, sorry. Wait. 1 second. You review the charging affidavit in both cases, did find probable cause for your arrest as to those cases. As to your driver license suspended case, the court is going to set your bond in that case amount $500. Going to make a condition that you're not operating a motor vehicle without a valid driver's license. As of 2021 MM 6040 AO, for a violation of domestic violence injunction, the court is going to set your bond amount of $50,000. Condition of your bond is you had no contact with the victim. You comply with the injunction in Florida in case number 2021 DR 101350. And all the stipulations contained therein. You ought to possess no weapons or firearms. The weapons and firearms you have need to be returned over to law enforcement within 24 hours of your release. When I'm appointing the public defender to represent you, you have a question, I'm going to have you talk to Mr. Brantz, because everything you talk to me about is on the record.
Your Honor, could you justify the large amount on the second count, $1,000 bond?
He has previous arrest for violation of domestic violence injunction, domestic violence battery. He has harassment convictions out of state. He has probation violations from out of state. He is already violated a court order. So the court has low confidence that he won't continue to violate court orders. Or alleged to violate the court order, I apologize. All right. Have a great day, sir. Good morning, ma'am. Can you tell me your name?
Good morning, Janae Boyd.
Ms. Boyd, you're here from a Seminole County case in 2019, 1 CF 124 for a violation of probation. The judge issuing your warrant in that case sets your bond at no bond. Your bond is going to remain at no bond. So we get you over to Seminole County. I'm going to appoint the public defender to represent you while you're here in my custody. You have a great day, ma'am.
Alter his behavior.
All right. Look at one thing. Want to appoint the public defender to represent
With the appearance, Your Honor.
Ms. Coulter. Only have an agency number. This is over the line arrest from Seminole County. The agency number 2021-0004833. Let's say your bonds. 2,500 and 500. So your bond out, be transported back to Seminole County. Good morning, ma'am. Can you tell me your name?
Leslie Crawford.
Ms. Crawford, you're here in the Volusia County case, 2020 102193 for a violation of probation out of Volusia County. Bond judge of Volusia County sets your bond at no bond. Your bonds remain at no bond. I'm going to appoint a public defender to represent you to get you on over to Volusia County. You have a great day, ma'am. Good morning, sir. Can you tell me your name?
Hugo Dominguez.
Mr. Dominguez, you're here in a Palm Beach County case, maybe 2012 CF 9425 for a violation of probation. Judge in Palm Beach County, set your bond at no bond. Your bond's gonna remain at no bond. Going to appoint the public defender to represent you to get you over to Palm Beach County. You have a great day, sir. All right, have a great day, sir.
Your Honor, Isaiah Fords is medical.
I'll appoint a public defender to represent Mr. Ford.
We'll waive the appearance, Your Honor.
Mr. Ford has 3 out-of-county warrants in front of the court this morning, one from Hillsborough, and a short case number, this is 222-87480. Bond's $2,000, gonna stay that bond. Another case, 2021 CF 2414 from Osceola County, gonna stay the bond amount of $1,000. He has another case, 2021 CF 6328AO from Polk County, gonna stay that bond amount of $1,000. Gonna appoint a public defender to represent him in those cases until we can get him over to those respective counties. Okay. All right. Good morning, ma'am.
Morning.
And can you tell me your name?
Rebecca Griffith.
Ms. Griffith, you're here from a Lake County violation of probation warrant in case 2020 CF 1737. Judge in Lake County set your bond at no bond. Your bonds remain at no bond. We're going to appoint a public defender to represent you to get you over to Lake County.
Okay, I have.
I'm not going to take any action on your 2021 CF 8628AO case. Good morning, sir. Can you tell me your name?
Alan Smith.
All right, keep your face covered, Mr. Smith. There you go. Appreciate it. So you're here on a similar county warrant in case 2019 MM1320AO. The judge in similar county set your bond amount of $995. Bonds can remain in set. Going to appoint the public defender to represent you until we can get you over to Seminole County. You have a great day, sir. That's right. Good morning, sir. Can you tell me your name?
Marcus Brock.
Mr. Brock, you're here in case 2019 CF 9370AO for a violation of probation. Judge signing your warrant in that case, set your bond at no bond. Your bonds can remain at no bond. Going to appoint the public defender to represent you in that matter. Cool. Have a great day, sir.
Sir.
Good morning, sir. Can you tell me your name?
Landy Ferreira, sir.
Sir, you're here in case 2020 CF 6986AO for a violation of probation, filed by, also on-view violation of probation filed by law enforcement. Court did review the charging affidavit, did find probable cause for that on-view violation of probation. Going to set your bond at $0 in that case. Sir, you're a violent felony offender of special concern. You're not going to be entitled to release on bail or bond on this case until your violation of probation goes to hearing. Going to appoint the public defender to represent you in your violation of probation case.
Yes,
You have a great day, sir.
Thank you, sir.
Good morning, sir. Can you tell me your name?
Jacob Harrison.
Sir, you're here in case 2020 CF 13106AO for a violation of probation case. Judge signed your warrant in your case, set your bond at $0. Your bond's going to remain at $0. Going to appoint the public defender to represent you in this matter. You have a great day, sir. Good morning, sir. Can you tell me your name?
Good morning. My name is Tyree Jones.
Mr. Jones, you're here in case 2016 CF 8201 BO for violation of probation. Judge in this case set your bond at no bond. Your bond's going to remain at no bond. Sir, you're a violent felony offender, special concern. You're not going to be entitled to release or bail on bond on this case until your violation of probation goes to hearing. I'm going to appoint the public defender to represent you in this matter. You have a great day, sir. Good morning, sir. Can you tell me your name?
DeAndre Pilcher.
Sir, you're here in case 2020 CF 4398 AO for on-view violation of probation filed by law enforcement. Court did review the charging affidavit, did find probable cause for that on-view violation of probation. Going to set your bond at $0 in this matter. Going to appoint the public defender to represent you. You have a great day, sir.
Yeah, Your Honor.
Yeah, the other case? Well, I did find probable cause because I read the same affidavit. In case 2021 CF 11658 AO.
Yes.
I gotta bring it back. I'm sorry. Yep. I didn't look up. Apologize. I'm sorry about that. You also have 2021 CF 11658 AO based on the same facts. And charge of possession of cannabis and possession of cannabis with intent to sell and deliver. Court did find probable cause for those two charges. Going to set your bond in count one, amount of $150. Count two, $1,000. Condition your bond, no drugs or alcohol without a valid prescription. You have a great day, sir.
So I can bond out or no?
You can bond out on the new case, but not on the violation of probation case. You'll be seen next Thursday, I believe. Tuesday. Wherever sunshine says it. All right, good morning, sir. Can you tell me your name?
David Richard.
Mr. Richard, you're here in case 2021 CF 558 AO on a on-view violation filed by law enforcement for violation of probation. Did review the charging affidavit, did find probable cause for that on-view violation.
Yeah, that's a warrant.
Sorry, it was a warrant. Apologize. Thought it was. Sorry, there was a warrant for your arrest for violation of probation. Let me look at that. Make sure I didn't miss it.
So you do have a right to appeal. If you wish to appeal, you'll need to file a
All right.
notice of appeal within 30 days of today.
All right, sir. Yes, sir. You're here in case 2021 CF 558 AO on a violation of probation warrant signed by Judge Bleckman. Judge Bleckman set your bond at no bond. Your bond's going to remain at no bond. I'm going to appoint the public defender to represent you in this matter. You have a great day, sir.
Toy Williams bonded.
One second. All right. Next question. All right, good morning, sir. Can you tell me your name?
Michael Muscat.
Mr. Muscat, you're here in case 2021 So 2019 MM 8918 AO for a violation of probation. Judge signed your warrant, set your bond at no bond. Your bond's going to remain at no bond in that matter. We're going to appoint the public defender to represent you in this case. You have a great day, sir. Oh, sorry, Mr. Branson, you want to enter denial on his behalf?
Please tell me your name.
My name is Ricardo Chang, Your Honor.
All right, good afternoon. You're here in 21 CF 11611, charged with burglary of a dwelling and trespass on property after warning. There is probable cause for this arrest. I'm going to appoint an attorney to represent you. I'll stay your bond at $5,000 on count 1, 100 on count 2. You can't return to this scene. You can't have contact with the victim. Do you understand what no contact means?
Yes, ma'am. It means I can't talk to him, but
Right. Yes, sir. Do you have a question?
Excuse me?
Did you have a question?
I want to explain myself. And not explain.
Well, hold on. Let me explain what we're doing today. So this is just about probable cause and bond. I'm going to give you a moment to talk to your attorney. You want to talk to him, Mr. Branson, then?
Yes, that's nice.
All right, sir. Having spoken with your attorney, do you still want to say something or do you want to wait?
Oh, wait.
Okay. All right, you can't possess or consume any controlled substance without a valid prescription. And at this time, I'm going to revoke your bond in 21 CF 5494. 54? I can't, is it 5? Okay, I can't read that. All right, good luck, sir. Please tell me your name.
Gary Harrison, ma'am.
All right, sir. A KPS was issued for your arrest in 20 CF 13562 for failing to appear for a status hearing on a charge of failure of sexual offender to report to sheriff's office every 30 days as a transient. The bond authorized on that KPS is $10,000, and I'll appoint an attorney to represent you. In 21 CF 9345, a warrant was issued for your arrest. It's also for a violation of sex offender reporting requirements. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you in this one as well. Your bond is $5,000, and sir, you understand that when you bond out, you have to maintain your reporting requirements. Do you understand? Okay, do you have a question for me or do you have a question for your attorney?
I mean, it's well, I'm homeless.
I know.
I never received any mail at my mom's address or nothing.
I think that if you think you have some defenses to the charge, you should talk to your attorney about it.
I have some attorney.
You do now. No, now you have an attorney.
I never had nobody.
That, it sounds like what you're saying is you have a defense to failure to appear, but I can't change that because it's a capias. So you want to talk to your attorney so they can raise that in front of the trial judge. Okay? All right, good luck, sir. Please tell me your name. Thank you. 21 MM 6043. Sir, you're here charged with possession of cannabis less than 20 grams. There is probable cause. I'll appoint an attorney to represent you. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. And then in 21 CF 11648, you're charged with burglary of a structure and petty theft. There is also probable cause for these charges. I'll appoint an attorney to represent you. Your bond is $3,500 on count 1 and $100 on count 2. You're not allowed to return to Heritage Prep School. You know where that is?
Yes.
All right, you can't go back there.
Yes.
Yes.
Can I have the bond drop down from the burglary structure? Because
No, not at this time, and I am contemplating revoking your bond in 21 CT 4806. Mr. Brands, is that what you wanted to be heard on?
It is a traffic offense, so I would just have you set a bond there, but as to the cannabis charge, what was the bond amount on that? I don't know if you-
Oh, did I not say it? It's $500. And what says the state is out on bond charge?
I apologize, Your Honor. I'll leave it at your discretion.
All right. I'm going to take no action on that at this time. Good luck, sir. I did not revoke your bond. Yes, sir. Please tell me your name.
Mike Bailey.
Thank you, sir. 21MM6048, you're here charged with resisting an officer without violence. There is probable cause. Is there an offer in this case?
It's an adjudication of guilt and credit time served.
Your Honor, I believe we would just have you set bond on this case. There may be some probationary issues here.
All right. At this time, sir, your bond is $500. That's it. Good luck, sir. Please tell me your name.
Johnny Diaz.
All right, sir, you have an out-of-county charge. It looks like a violation of probation out of Volusia County, 2133138. There's no bond authorized at this time, and I'll appoint an attorney to represent you. We'll notify Volusia County that you're here so they can transport you. Additionally, 21MM6049, you're here charged with resisting an officer without violence. There is probable cause. Is there an offer in this case?
No, Your Honor.
All right, I'm going to appoint an attorney in this case. Your bond here will be $500. Good luck, sir. Yes, sir. I'm sorry, what?
Can I say anything?
You can say anything you want, but everything you say is being recorded and can be used against you later.
Yeah, so I was, sorry? I'm not gonna say anything bad. I was just crossing the street, and if anything, I was jaywalking, but I was just crossing the street, and the officer out of nowhere came down the sidewalk and was like, "Hey, what are you doing?" And he said that he was yelling at me before, and I ran after he yelled at me, which was, I didn't hear him yelling at me. So I don't really understand.
It sounds like what you're saying is you think you have some defenses. This is not a jury trial. I'm not telling you you're guilty. What I'm telling you is there's probable cause. That's all. What that means is there's cause to believe you probably resisted an officer without violence. That's all this means today. But it sounds like you think you have some defenses. So on that green piece of paper is a phone number for you to call to talk to a public defender. That's who I've appointed to represent you. You want to call them and tell them you have some defenses because they can negotiate with the state on your behalf. And I don't even know if the state's going to file the charge. They may not. The state could drop it and you could be released on it.
So I have to go to the next court date?
Yes, unless the state drops it. Good luck. Please tell me your name.
My name is John Fox.
Thank you, sir. 21MM6036. Sir, you're here charged with trespass on property after warning.
Yes, ma'am.
I'm going to appoint an attorney to represent you. Your bond in this case is $500.
Your Honor, there was an offer.
I'm not inclined to accept it.
Okay.
Is it credit time served?
It's an adjudication of guilt, credit time served, no return to the 7-Eleven at 3400 Conway.
Not doing that.
I'm willing to take it.
Then it's in your discretion to set bond, Your Honor.
Yes. Who just said that?
Mr. Fox.
Yeah, Mr. Fox, I'm looking at your record. I show that you're, hold on 1 second.
I haven't been in trouble for a long, long time.
I have a sexual predator,
No.
and you may not have been. I see that your last conviction on what I have is 1999.
Yeah.
But also that you have a very violent history, including sex offenses in several different states.
No.
You have an active warrant out of Ohio for failing to register as a sex offender. So at this time, I am not inclined to sentence you to credit time served.
May I speak?
You can say anything you want. Everything you say is being recorded and can be used against you later. So let me explain what we're doing here today and what your options are. Today is about probable cause and bond. You have the option to enter a plea of not guilty and will continue your case to be heard at a later time. If you want to enter a plea of guilty or no contest, you have the right to do that. But if you do that, you're going to give up certain constitutional rights, like your right to remain silent, your right to a jury trial when one is required, your right to call witnesses on your behalf and present any defenses you have, your right to force the state to prove the charge against you. You're also giving up your right to testify on your own behalf. Except that I will let you say anything that you want to say. So if you want to enter a plea of guilty or no contest today, you can do that. I'm happy to listen to anything you say, and perhaps what you say might convince me to sentence you to credit time served. I just don't know that until I hear from you. This is arrested as a first-degree misdemeanor, right, Counselor?
I was looking, Your Honor. Just a minute. Yes, Your Honor, it's an M1.
All right. So, Mr. Fox, I just want to make sure you understand, this is charged as a first-degree misdemeanor, which is punishable by up to a year in jail and a $1,000 fine. I'm not suggesting I would sentence you to that. I just want to make sure you understand that's the maximum penalty. So if you want to enter a plea of guilty or no contest, I'll qualify that plea and accept it. I'll hear anything you have to say. I might sentence you to credit time served, but I could sentence you to up to a year in jail. So I want to make sure you understand that.
Yes, ma'am.
Before you say anything else, I'm going to have you raise your right hand.
Well, for the record as well, Your Honor, I did advise him that he should bond out and speak to an attorney before entering a plea of no contest, as the terms of the state's offer may not apply anymore, and he still wishes to speak to the court.
All right, right. Can you swear me?
Yes, ma'am.
All right, sir.
Your Honor.
So we just had, you can put your hand down now. We just had this discussion about the rights that you're giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am.
Do you understand that if you're on probation anywhere, this plea could violate that?
Yes, ma'am.
You understand if you're not a U.S. citizen, you can be deported?
Yes, ma'am. I am in sound and holy mind.
Okay. Well, thank you. I appreciate that. Before you tell me anything about the facts, I just need to ask you a couple more questions. You just said you're of sound mind and body. So have you ever been diagnosed with any mental health issues?
I have post-traumatic stress disorder a few times over. I also have abandonment depression. I'm pretty much, that's it, ADD. Simple stuff. My family died in a fire when I was young, and ever since then, I've been in counseling my whole life. And yeah.
I'm sorry to hear about that, but I have to ask you, are you suffering any effects from any of those issues today?
No, ma'am. I'm actually been really well. I just took a walk and realigned myself.
All right, so are you under the influence of any drugs or alcohol today, or anything that would impair your ability to understand what you're doing?
No, but I am going through detox from alcohol, and I've been trying to quit now for a few months. My father died, so I am suffering a little bit of that. The 24th was his anniversary, and that's why I'm in Florida, just to go and give my house away to my uncle and his family so they could live and go to good schools. So they charge them $300 a month. That's all I get. And I'm trying to get back to Oregon and grow and get everything taken care of, because there was a misconception in the courts there saying that I was supposed to register, but I don't have to because it was from 2000, and the registration laws for an F6 was not a thing. So that's why they keep re-releasing me over and over again for that, and that's why there's so many arrests on that, because it's an old thing that's not even applicable.
All right, thank you. I appreciate that, and I am sorry to hear about your dad. I know that's difficult. But again, I have to ask you, with everything you have going on,
Yes,
is it
ma'am,
affecting your ability to understand what you're doing here today?
No, I just want to take responsibility for what I've done and move on with my life and make sure that everything is okay.
All right, then I'll ask you, at this time, Mr. Fox, how do you wish to plead to the charge of trespass on property after warning?
Guilty, ma'am.
I'll accept your plea of guilty. I find it's freely and voluntarily made. At this time, what else would you like to tell me, Mr. Fox?
I take responsibility for my actions. I've gone through a lot of stuff like this, being the way I look, the way people think I'm homeless, traveling. I have utmost respect for people and everything I've learned through time and through counseling, to respect others. I've never really had a violent charge or assaults or anything like that. I've always been a peaceful person. I have those different charges, and they got dropped all the way down to an F6, which F6 don't really exist. They made up a charge for that just to be able to give me a conviction when I got out. I was looking at the rest of my life in prison, and I only did 5. And the counseling and the therapists that I saw say I was of sound mind and I wasn't a threat. There's many times I just want to make people happy. I tell jokes. That's what I do for a living now. I'm a sit-down comedian. I just came from California. I walked from San Francisco to Tijuana to clear my mind and to find myself.
It's a long walk, Mr.
Yeah,
Fox.
it was 9 months.
So let me ask you, what were you doing at the 7-Eleven?
I had a sign that said, "Smile, smile, smile, there's nothing else to do." And the other side said, "You're awesome. Thank you for being you." And I was just standing on the sidewalk, and somebody pulled up onto the sidewalk. I stepped off the sidewalk onto the property, and as soon as I did that, the officer that was watching me pulled up real quick. I took a few steps back, and then they pinned me on the property. But I did jump onto the property to avoid a car, and because they were driving on the sidewalk. And so, I am guilty. I shouldn't have even been in the area, truthfully, because you can, it's called seemingly unimportant decisions, SUDs, and you just have to remember that if you put yourself in a situation and walk down the street with money in your pocket, they sell drugs, you're going to end up buying drugs. And so I have learned that, and I just want to make the world a better place every day. And I love my life. I don't have my mother, my father, my brothers. I don't have anybody anymore, and sometimes I get really sad, and I just want to talk to people. And so I go to public places, and I tell jokes, and that's...
So, Mr. Fox, if I order you not to go back to the 7-Eleven, Are you going to listen?
Yes, ma'am. Yes, ma'am, I'll stay away.
All right.
Stay far away.
At this time, I'm going to adjudicate you guilty. I'm going to
Thank you.
sentence you to the 2 days that you've spent in jail.
Thank you.
I have to order that you pay court costs. I'll give you a year to pay that. I'm also going to order that you can't go back to that 7-Eleven. You understand, sir?
Yes, ma'am.
All right, good luck, Mr. Fox. You have 30 days to appeal in writing.
Your Honor, I approach.
Yes. Thank you, Rebecca, for this. I thought about explaining it to him, but I thought, I don't think, it doesn't matter if I explain it. I'm ready.
Derek Kinzer is medical.
All right, 21MM6045. There is probable cause. Mr. Brandt, I'll appoint your office.
We'll waive the appearance, Your Honor.
All right, I'll stay the bond at 500, 100, and 100 with a no return, no alcohol or drugs of any kind. I'm revoking 21MM5732.
Lloyd is medical.
21MM6052. Mr. Brandt, I'll appoint your office.
Waive the appearance as well.
All right, there is probable cause. Did you want to be heard on bond, Mr. Brandt?
I believe if the client was present today, they would have been no billed. I would just have you perhaps release ROR.
Is the state dropping this charge?
At this time, Your Honor, I am not. As Mr. Brands indicated, if he was present in court, I would have dropped it, but as he is not, I'm not. As he's not present, I'm not dropping the charges.
Why?
I generally like to have them present in court, Your Honor, but at this time, I'm not dropping it.
Okay.
I would just have you release ROI, Your Honor, if possible.
Is he here on something else? All right, I'll release him on his own recognizance. No co-defendant contact, no drugs.
Thank you, Your Honor.
Thank you. 21MM6050. Mr. Brandt, I'll appoint your office.
Waive the appearance, Your Honor.
I don't know. I have him as Nicholas O'Neill. What's the case number?
There's also a John Doe.
Yes, that's him. Yes, Nicholas O'Neill. You waived his appearance?
I waived his appearance, Your Honor, yes.
His bond is $250, no return.
Corey Vankirk bonded.
Okay. Please tell me your name.
DeAndre Washington.
21MM6044. You're here charged with possession of cannabis less than 20 grams and possession of drug paraphernalia. I'm going to appoint an attorney to represent you. There is probable cause in this case. Your bond is $500 on count 1, $100 on count 2. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. At this time, I'm revoking your bond in 21 CF 7010. Good luck, sir.
Good afternoon, Your Honor.
Good afternoon. Tell me your name, please.
My name is Joseph Dyer.
You're here because a capias was issued for your arrest in 21 MM 51 for failing to appear for trial on a charge of battery, petty theft, and criminal mischief. There's no bond authorized on that capias, and I'll appoint an attorney to represent you. Yes, sir.
I have an explanation. I was incarcerated at
Hold
the
on.
time of the court date.
Okay.
The state offered my public defender, Andrew, with time served. I've had 63 days already served. I want to resolve this today because I have to get back to Atlanta. Is there any way I can plead?
No,
out?
because it's a battery, and so the victim has the right to be at the court date for, if you enter a plea.
Offer. There's no victim coming to the court date. They made an offer to me, and I was supposed to sign on the 27th, but I was incarcerated.
I can't because of the charge. So I believe what you're telling me, but I can't do it. So call the number on that piece of paper and ask to speak to your public defender right away and see if they can get you in front of the trial judge. I can't change it today. Sorry, sir. Good luck.
To be in front of that judge.
Right.
Yeah.
Yes. Good luck.
I'll email him, okay?
Okay, thank you.
Yes, sir.
Yes, sir. Good luck. Please tell me your name.
Julian Graham.
21MO989. You're here charged with 2 counts of violating state misdemeanors and failure to produce identification. Was there an offer in this case?
It's the city offer, Your Honor, withhold of adjudication and credit time served.
Mr. Brands?
Yes. I believe he wishes to enter a plea, Your Honor.
Please raise your right hand, sir.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
All right, sir. You had a chance to speak with an attorney about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights? Do you have any questions for me about them? You have to answer out loud.
No.
All right, there's a form in front of you that further explains those rights. Did you have a chance to look over that form?
Yes.
Do you have any questions for me about it before you sign it?
No.
You understand if you're on probation anywhere, this plea can violate that.
Yes.
If you're not a U.S. citizen, you can be deported.
Yes.
All right, sir, at this time, how do you wish to plead to violating state misdemeanors, 2 counts, and failure to ID?
No contest.
I'll accept your pleas. I find they're freely and voluntarily made. I'll withhold adjudication, give you credit for the time that you've been in custody. That's 2 days. I have to order that you pay court costs, and I'll give you a year to pay them. Good luck, sir. You have 30 days to appeal in writing. Please tell me your name.
David Mann.
21MO990. You're here charged with disorderly conduct. Was there an offer in this case?
City offer, withhold of adjudication and credit time served.
May I approach the clerk, Your Honor?
Yes. Did you have a chance to speak with Mr. Mann? What? Oh, okay. Okay. All right, Mr. Mann, raise your right hand, please.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
So you had a chance to speak with an attorney, and you can put your hand down. You reviewed that form.
Right.
It explains the rights that you're giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes.
Do you have any questions for me about them?
What is exactly the charge again?
It's disorderly conduct. It's a misdemeanor.
Okay, thank you.
It's a second degree, right?
Yes, Your Honor.
So it's punishable by a maximum of up to 60 days in jail or a $500 fine. You understand that?
Yes, ma'am.
You understand if you're on probation anywhere, this plea can violate that?
Yes.
I'm not saying you are, I'm saying if you were, this plea could violate that.
Yes, I'm not on probation.
All right, I have to ask everyone. You understand that if you're not a U.S. citizen, you can be deported?
Yes.
All right, at this time, sir, how do you wish to plead to disorderly conduct?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for 2 days that you've been in custody. I have to order that you pay court costs, sir. Do you have a job?
No, ma'am.
Do you have a home?
No.
I'm going to reduce that to a lien. All right, good luck, sir. You have 30 days to appeal in writing.
Okay. Sign right here.
Your Honor, Mr. Tackett is mental health.
21MO991, mental health. Mr. Brands, I'm going to appoint your office.
We'll waive the appearance today, Your Honor.
All right, there's probable cause. I'll stay the bond at $250. That's it.
Roderick Eager, bonded.
What about Deneen?
Bonded, Your Honor.
Goddard, Philippe Goddard bonded. Allison Kovark bonded. Jeremiah Ledesma refused.
21 CT 1199, I'll find his refusal a willing waiver of his appearance here today. It's a capias. I'll stay the bond at $10,000 and appoint the public defender to represent him.
Gianna Rosado, Alondra Rosado, behavior.
All right, 20 CT 2103, it's a capias, Mr. Brands, I'll appoint your office.
We'll waive the appearance, Your Honor.
Okay, the bond is $500 on that one. 20 CT 2101. The bond is $750, and again, I'll appoint your office.
Your Honor, Adams Medical.
21 CF 11670. Mr. Brandt, I'm going to appoint your office in this case.
We'll waive the appearance, Your Honor.
There is probable cause. Give me one moment. I need to review something. Yeah. Did you wish to be heard on bond, Mr. Brandt? There is probable cause.
It was an interesting set of facts, Your Honor. Taking those into account, he did, according to the arrest affidavit, Mr. Adams did let officers know right away and didn't give any resistance at all to the procedure. I would just have you set a low bond in that good faith that Mr. Adams gave to the arresting agent.
Well, he says, before anything, I'ma tell y'all, I just came from my mama's house, and my brother had his weapon there, and he asked me if I could bring it to him. So he was overly cooperative, I think.
I agree, Your Honor. I don't know what, I didn't double check the bond schedule, but.
I think it's probably bond schedule, but I feel like the facts indicate that he's very not a flight risk and will return for court because he's.
Would you be opposed to a $100 bond?
A what?
$100?
I won't do that, but I will reduce it to $1,000. No weapons, firearms, or ammunition. Hold on one second. Does the state have any thoughts on bond for this defendant?
I'm okay with the $1,000, Your Honor.
I would do what you asked, Counselor, except he's 18, recently 18, with a juvenile, very recent conviction for battery. So that's the issue.
Understood, Your Honor.
All right. That's it. Please tell me your name. In 19 CF 14852, a capias was issued for your arrest for failing to appear on charges of burglary of a conveyance, fraudulent use of a credit card, petty theft, and criminal mischief. There's no bond authorized, and I'll appoint an attorney to represent you. Good luck, sir.
Thank you.
Blacktail deer is medical, Your Honor.
21 CF 11662. Mr. Brandt, I'll appoint your office.
We'll waive the appearance, Your Honor.
There is probable cause. I'll stay the bond at $2,500. Can't drive without a valid Florida license. Please tell me your name.
Bar Chops.
21 CF 11660. You're here charged with attempted aggravated battery with a firearm, aggravated assault with a firearm, resisting without violence, possession of cannabis under 20 grams, possession of drug paraphernalia, and carrying a concealed firearm. At this time, I'm going to appoint an attorney to represent you.
Yes, ma'am.
There is probable cause. Does either party wish to be heard on bond?
Nothing from the state, Your Honor.
As long as you're within the bond schedule, we would agree, Your Honor. I believe the attempted ag bat would be $2,500, Your Honor.
All right, your bond on count 1 would be $2,500. Count 2 will be $2,500. Counts 3, 4, and 5 will be $100 each. On count 6, $150. You can't possess a weapon of any kind, firearm, or ammunition. Do you understand?
Yes, ma'am.
You can't possess or consume any controlled substance without a valid prescription. You can have no contact with the victim. Do you know what no contact means?
Yes, ma'am.
Do you live at this apartment complex?
No, ma'am. I was at a friend's house.
Okay, so you can't go back to that complex?
Yes, ma'am.
So your friend has to come to your house for now. You can't go back there. You understand?
Yes, ma'am.
All right, good luck. Please tell me your name.
Matthew Clark.
21 CF 11607, you're here charged with attempted burglary of a conveyance, possession of methamphetamine, possession of drug paraphernalia, and loitering or prowling. I'm going to appoint an attorney to represent you in this case. There's at least one additional felony charge in there that they didn't charge. All right, sir. Your bond will be $1,000 on count 1, $150 on count 2, and $100 on counts 3 and 4. You can't possess or consume any controlled substance without a valid prescription. You can't have contact with any known drug dealers. You can't return to Cortland Jubilee Park Apartments. Do you understand that?
Yes, ma'am, I do.
You can have no contact with the victim or any witness in this case. Mr. Brandt, I'm inclined to revoke his bond in 21 MM 3946.
I understand, Your Honor, but I would, if you are inclined to revoke, I would just set a higher monetary bond. Reiterate the court's order on that trespass as well.
Can you do me a favor, counselor? Can you point your microphone toward you and let's...
I think...
I can hear you fine, but I'm wondering if that will help with the feedback. Like maybe it's pointing at something. If you point it towards you.
Move my phone over here. I think if I directly talk into it, is that better?
No, but what I'm saying is instead of having it up, do this.
Towards
Let's
me?
see if that stops some of the feedback.
Okay.
Like I'm wondering if it's pointing at that. I can't figure out the feedback and I'm trying to fix it and I can't.
It's been in 5 different positions the last month, I think.
So what you're telling me is this probably isn't going to help.
It's probably it might help.
Worth a shot. All right. Can the state advise in 21 MM 3946, what was the arrest charge? It's transferred from a felony. You know what? Never mind. I'm not going to take any action on that case. Good luck, sir.
Your Honor.
Please tell me your name. 21 CF 11616. You're here charged with possession of heroin and drug paraphernalia. There is probable cause, and I'll appoint an attorney to represent you. Your bond is $1,000 on count 1, $100 on count 2. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Good luck, sir.
Isaiah Cabrera bonded. Frank, your name, your medical.
21 CF 11665. I'm going to appoint your office, Mr. Brandt.
We'll waive the appearance, Your Honor.
There is probable cause here. Bond is $5,000 on count 1, $150 on 2 and 3. No co-defendant contact, no witness contact, not returned to, isn't that an outlet store? Does anyone know? 5269 International Drive.
I believe so, Your Honor.
It says Tommy Hilfiger. I think that's the outlet, so he can't go back to any of the outlets.
By the Fun Spot Way.
Right.
Theme park.
All right.
Leslie Hammer, hospital.
All right. 21 CT 5971 and 72. Mr. Brands, I'll appoint your office in both of those.
We'll waive the appearance in both, Your Honor.
All right, there's probable cause. Bond is $1,000 on count one, on the DUI, $500 on the driving while license suspended. Cannot possess or consume any alcoholic beverages, subject to random alcohol screens. Can't possess or consume any controlled substance without a valid prescription, subject to random drug screens. Cannot drive without a valid Florida license. 21 CF 11668. Again, Mr. Brands, I'm going to appoint your office.
We'll waive the appearance, Your Honor.
Thank you. There is probable cause. Bond is $1,000. All the same conditions, except not the license, but the same drugs, alcohol, and in this case, no unsupervised contact with any minor child under the age of 18. Must comply with any plan set in place by DCF. Yes. Please tell me your name.
Michael Hendricks.
Good afternoon, sir. 21 CF 11657. You're here charged with burglary of a structure and trespass on property after warning. There is probable cause. Your bond is $3,500 on count one, $100 on count two. Sir, you can't return to, what's the name? It's on International Drive. Does the state have the name of the resort?
I'll look, Your Honor. But probably.
I'm somehow missing it in this PC affidavit. I have the address. Do you know where 8001-6 International Drive is? I don't know where that is. I'm asking if you know. Yes, sir. I can't hear you.
I think the Wyndham's.
Oh, the Wyndham. All right, so you can't go back to the Wyndham. You understand that? You have to answer out loud.
Yes.
Thank you, sir. You can't have any contact with any witness in this case. Good luck, sir. Please tell me your name. 21 CF 11664. You're here charged with burglary of an occupied structure, retail theft. But is that a conspiracy charge or just retail theft? $750 or more, and grand theft. There is probable cause. I'll appoint an attorney to represent you. I'll stay your bonds at $5,000 on count one, $150 on count two, $150 on count three. You can't return to the outlets on International Drive. Do you understand?
Yes.
You can't have contact with any co-defendant or witness in this case. And that's all. Good luck. Please tell me your name.
Nicholas Edward Ingerman.
A warrant was issued for your arrest in 21 CF 7392, charging you with failure to report and re-register as a sex offender. Is that right? Hold on one second. Yes, offender. Nicholas Ingerman. We skipped one. I don't know why. Another judge has already found probable cause in this case. Your bond is $15,000. You understand that you have to comply with all of your sex offender reporting requirements? And then in 20 CF 13990.
I had a question for the court on that, Your Honor.
Okay.
Because the court date was today. I wondered if he went there.
What are you talking about?
I got rescheduled. My attorney showed up and they rescheduled it because they're trying to put me in a program. So they said they're giving me enough time to get into that program.
The possession of firearm?
My attorney represented me today, this morning at 9 o'clock at that court date.
Did you go?
No, ma'am, I didn't have to go. He waived my appearance.
Is it your office?
I believe so, Your Honor. It was just, I believe it was a plea hearing, but
I have a private attorney.
Oh, I'm sorry.
Oh.
He just put in the paperwork on the 26th.
What's his name?
Matthew something, I'm not really sure. My mom got it for me.
Okay.
Yes, ma'am. But they continued the court date today. I talked to her this morning.
Well, I'm inclined to revoke that. He also has 2 Osceola County cases that are open.
Yeah, they were all notified of that, ma'am. Everything.
I guess, Your Honor, my argument would have been, for the out on bond case, the participation in the process, and it sounds like if his attorney said he didn't have to be there, that they waived his appearance, I would just have you take no action, or if you do revoke, set a higher bond. I'm speaking as a friend of the court, of course, not speaking on behalf of his attorney.
It's a trafficking in meth with a weapon is the most serious charge on that case. And while out on bond for that, he was arrested for this warrant, and I verified the dates.
I've been to court 3 times with this warrant, man. Like, I'm not.
It's not about whether you make your court dates, it's that if you're out on bond for committing a criminal offense and you get arrested for committing a new criminal offense, the court can revoke your bond, and does in many cases.
Yes, ma'am. I understand.
That's a very serious charge. I'm going to revoke it at this time, so get in touch with your attorney right away so that they can file a motion in front of the trial judge. Good luck, sir.
We were appointed in the current charge?
Yes, in the new law. Counselor, who's your case?
Good afternoon, Your Honor. Jonathan Rose on behalf of DeAndre Wash to the court. Saw Mr. Washington before I got here. I'm requesting that the court readdress that matter briefly.
Oh. Do you have the case number? Does that help you?
The case number on the new one is 2021 MM 6044.
What was he charged with?
Possession of less than 20 grams of cannabis and possession of drug paraphernalia.
It was a pleable, Your Honor, in the pleable section.
See if we can find that paperwork. Washington? Did I revoke an out on bond case?
Yes, ma'am.
He was out on bond in trafficking, and I revoked it.
He was out on bond on possession with intent, judges.
Oh, possession with intent. Sorry,
Understood? Understood.
trying to remember. There we go. You represent him in 21 MM 6044?
Yes, ma'am.
All right. I at least have my order. On what do you wish to be heard, counselor?
I understand the court has revoked his bond on the matter that he was previously put on bond on, and I am requesting that the court address probable cause on at least one of the counts in the new charges and consider revoking and setting new bonds on the case that he is on bond on.
All right, one second. I need that PC affidavit again then. In which one are you challenging probable cause?
Well, I would challenge probable cause in both charges currently, but most specifically the paraphernalia. There were cigars that the officer has charged as drug paraphernalia, but there was no indication that those cigars had been used as drug paraphernalia, that there was any sort of residue of marijuana or any other drug in those. The fact that they were perhaps in close proximity to marijuana residue does not make those paraphernalia. It makes them simply cigars. With respect to the marijuana count, it's It's literally a residue amount of marijuana, so based on the officer's description of it, less than 1 gram of marijuana in the center console, there is no evidence whatsoever that Mr. Washington would have been aware of the presence of the quote-unquote residue of less than 1 gram of marijuana. There were no statements that are in this report that are indicative of him being aware of it. So given those factors, I would suggest that the court could very well find that there is no probable cause on either count. In the event that the court does find probable cause on either count, given the weakness of the case and given that the state attorney's office at this point is largely not prosecuting this kind of cases and allowing people to end all of these to go into diversion programs or not prosecuting them at all, I would request that the courts just do what you have to do, but reset low bonds on the case that he was already on bond on.
All right, thank you, Counselor. What says the state as to the probable cause challenge?
Your Honor, the charge is less than 20 grams. It does not have to be a particular amount, only less than 20 grams, so that it is flakes or residue, as long as it can be determined to be marijuana or cannabis, that is sufficient. With regard to the paraphernalia, there was also mention of cannabis leaf wrapping paper to be the paraphernalia, so as well as the cigars, it's also the wrapping paper. No offer was made on this case for the simple fact that defendant Mr. Washington was out on bond on a cannabis charge over 20 grams, and while still out on bond, he picked up another cannabis charge, Your Honor.
I understand. Thank you, Counselor. And I'll tell you what I read in the PC affidavit when I initially found probable cause for the paraphernalia. It says, I recognize the cannabis leaf wrapping paper to be paraphernalia, not the cigars.
I understand, Judge. The way that I read that, it seems like he is referring to the quote-unquote cannabis leaf wrapping paper as the cigars because there's no previous mention of something that would be described as cannabis leaf wrapping paper prior to that sentence.
Okay. The other reason that I initially found probable cause that you haven't addressed, so I'd like you to if you can, is the law enforcement officer states in the probable cause affidavit that I could smell the strong and distinct odor of cannabis emanating from within the vehicle. So
I would say that gives him probable cause to search, but I don't think that's probable cause of knowledge of the fact that A, it is marijuana, or B, that he's aware that it's there, given the minuscule amount demonstrated by law enforcement, a residue amount. Though I understand your concerns.
all right, give me a minute to think about that. Because my initial thought would be, if the law enforcement officer can smell the strong and distinct odor, then someone inside the vehicle can surely smell it. So to argue he had no knowledge of it, however, to your point, there's no statement from your client that he smelled it.
Correct.
Give me 1 second, let me pull this statute. All right, just so both of you are aware, I pulled up the statute. 893.147 for paraphernalia, and then 146 directly preceding that. Says, in determining whether an object is drug paraphernalia, a court or other authority or jury shall consider, in addition to other logically relevant factors, the following: statements by an owner or anyone in control of the object, the proximity of the object in time and space to a direct violation of the act, the proximity of the object to controlled substances, the existence of any residue, that's not present, direct or circumstantial evidence of the intent of an owner or anyone in control of the object, the manner in which the object displayed for sale, the existence and scope of legitimate uses for the object in the community.
Judge, briefly, with respect to the paraphernalia charge, I'm just looking at 2012 case, just the first thing I could find on point, from the 3rd DCA, CMV State, 83 Southern 3rd 947. Just going to quote from this case very briefly. To sustain this charge referring to possession of drug paraphernalia, the state was required to prove not merely that CM, the juvenile, possessed drug paraphernalia, but that CM possessed drug paraphernalia and either used it or intended to use it to inhale controlled substances, in this case marijuana. So based on that standard, I would say that there is not probable cause.
All right, Counselor, I appreciate your arguments, and I think as to the paraphernalia, I agree with you. After reviewing the statute, and then thank you for the language from the case, I don't think there is probable cause that the cannabis leaf wrapping paper or the cigar is necessarily paraphernalia. However, I do think there's still probable cause to believe your client possessed cannabis, however thin, to your point earlier. So I'm going to say that bond at $500. But in the 21 CF 7010 that I revoked earlier, instead of holding him at no bond, I'm going to reset those bonds.
Very good.
We typically double it. But in this case, what I'm going to do is set it at $2,500 on count one and 100. I'm going to reset those same bonds. So $2,500, 100, and 100.
Very good.
With all the same conditions. Mr. Washington, you understand that?
Yes, ma'am.
All right. Thank you, Counselor. Anything further?
No, Your Honor, thank you very much. Have a great day and a great weekend.
All right, you as well. Good luck, Mr. Washington.
Thank you.
What? It's fine. Tell me your name, please.
Karina Johnson.
21 CF 8047. A warrant was issued for your arrest, ma'am, charging you with robbery with a firearm and false imprisonment with a weapon. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. What says the state as to bond?
Your Honor, robbery with a firearm is punishable by life. I would ask defendant be held no bond.
Mr. Brantz?
No argument from the defense, Your Honor, pending an Arthur hearing with her attorney.
All right, at this time, you'll have no bond on count 1. Your bond on count 2, I'll stay at $5,000. You can have no contact with the victim or the co-defendant in this case. Do you understand what no contact means?
Yes.
You can't possess a weapon, firearm, or ammunition. You can't return to the Royal Inn for any reason. Do you understand?
Yes.
All right, good luck, ma'am. What happened with Ron Hudson?
I'm sorry, Your Honor, Ron Hudson had bonded.
Okay. Thank you. Please tell me your name.
Maya Johnson.
Good afternoon, ma'am. 21 CF 11667. You're here charged with burglary of an occupied structure, retail theft, grand theft, and providing false ID to law enforcement. There is probable cause. I'll appoint an attorney to represent you. Your bond is $5,000 in count 1. On count 1, $150 on 2, 3, and 4. You can have no contact with any witness or co-defendant in this case. Do you understand?
Yes.
You can't return to the outlets on International Drive for any reason. And in 21 CF 585, a capias was issued for your arrest for failing to appear for a trial management conference on a charge of grand theft. There's no bond authorized, and I'll appoint an attorney to represent you. Good luck, ma'am.
Your Honor, Eddie Jones, Sherry bonded.
And Angel LeBron bonded? Please tell me your name.
Joel Lopez Morales.
A warrant was issued for your arrest in 21 CF 7347, charging you with robbery armed with a deadly weapon. Another judge has already found probable cause. I'm going to appoint an attorney to represent you.
For the record, Your Honor, I believe the case is the case 7437,
Oh, 7437. You're right.
just for the record.
Thank you. Does the state wish to be heard on bond?
Robbery with a deadly weapon is punishable by life, Your Honor. I would ask defendant be held no bond.
Mr. Brantz?
No argument from the defense, Your Honor, pending an Arthur hearing with his attorney.
All right. At this time, you'll have no bond on this charge. However, even while in custody, you can have no contact with the victim in this case. Do you understand?
Good.
Good luck. Please tell me your name. Sir, can you tell me your name?
David Manuel, ma'am.
All right, sir. A warrant was issued for your arrest in case number I don't have. 21 CF 11679.
65.
What?
I'm sorry, 11659.
Hold on.
I do have a PC challenge.
Oh, I see it. No, I have 59 and 79.
I'm sorry.
59 is the possession of cocaine. 79 is the warrant.
I have a PC challenge for the possession.
Okay, hold on, we're not there yet.
Thank you.
First, 79. So in this case, sir, a warrant was issued for your arrest. Another judge has already found probable cause, charging you with 2 counts of ownership, lease, rental, or possession of a structure known for trafficking in a controlled substance. Oh, I'm sorry, 1 count of trafficking, 1 count for selling, 1 count ownership, lease, rental, or possession of a structure known for manufacturing a controlled substance, trafficking in fentanyl, possession of a controlled substance with a firearm, possession of a controlled substance with intent to sell, possession of a controlled substance within 1,000 feet of a place of worship with intent to sell, manufacturing a controlled substance within 1,000 feet of a place of worship, possession of fentanyl, possession of a firearm by a convicted felon, possession of ammunition by a convicted felon, and possession of drug paraphernalia. So it's 12 counts total. I'm appointing an attorney in this case to represent you. I'll stay the bonds as listed. So count 1, 2, 3, 4, and 5, your bond is $2,500 each. Count 6, it's $7,500. Count 7, it's $10,000. Count 8, it's $10,000. Count 9, it's $10,000. Counts 10 and 11, it's $5,000 each. Count 12, it's $500. So the total bond is $60,500.
I can't afford to burn out. Could I have a burn reduction or anything?
Not at this time. Your attorney is going to have to file a motion in front of the trial judge. But your special conditions of bond in this case are you can't possess a weapon of any kind, firearm or ammunition, and you can't possess or consume any alcohol or drugs. Now, in 21 CF 11659, I'm appointing an attorney to represent you. Mr. Brantz, you said you wanted to be heard in this case?
Yes, Your Honor. As to the possession of cocaine with intent to sell and deliver, I know the arrest affidavit said there were 12 pieces, but under the totality of the circumstances, there weren't any baggies, there wasn't any cash, there wasn't a scale, and I don't believe there was any evidence of transactions. I would just have you find probable cause for possession of cocaine.
I would say that 12 pieces is excessive for individual use, Your Honor.
I believe we've had this discussion before, and I haven't looked this up, but back in the old days when I was a prosecutor, I believe there was Florida case law that said amount is not sufficient to be possession with intent to sell. Does anyone know if that case law is still?
I think that's the case I usually cite is Nelson v. State, which was 6 pieces, but they also had baggies and I think there was cash. But even with those other items, there wasn't enough probable cause for the jury to find a guilty verdict for intent to sell. So my argument, I suppose, using that case law would be just the pieces by themselves, without any of the other paraphernalia, would only find PC for possession. And as far as personal use, I don't know how personal use works, but it could, you know, I don't know how much you buy at once for personal use.
Right. I think you're correct, Counselor. I agree with your argument. So in this case, I find that there is probable cause for possession of cocaine. That's count 2. I'll set the bond at $1,000 on that. I don't think there's probable cause for possession of cocaine with intent to sell. But sir, it's the same conditions as in the other case. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand?
I'm just living in the house.
Good luck, sir.
Which way?
Yes, because there's no probable cause for that charge. Oh. Please tell me your name.
Terrell Mano.
Mano?
Yes.
The one we skipped. 21 CF 11663. You're here charged with possession of fentanyl and drug paraphernalia. Sir, there is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000 on count 1, $100 on count 2. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand? Good luck, sir. Do we have your case coming in soon?
I believe so, Your Honor. I'm
Okay.
Keith Smith. I'm here on behalf of Mr. Velasquez Rodriguez.
Okay. Sorry, I know sometimes you guys have to just wait because
I'm in no rush, Your Honor.
thank you. Takes time to get everyone.
Make an argument anyway, I already had one.
Sir, please tell me your name.
Monte Payne.
A warrant was issued for your arrest in 21 CF 3209 for violating pretrial release. There's no bond authorized. I'll appoint an attorney to represent you.
As to the out on bond case, Your Honor,
Nope, it didn't help.
find a new position.
I don't show what date he bonded out.
That was my issue as well, Your Honor. I think he bond, on the current charge, he was on pretrial release, which I believe he bonded 3/19. And then as to the out on bond case, he bonded 5/29. So. Does that make sense? So one.
So he was arrested for another aggravated battery upon a pregnant person while out on bond for aggravated battery upon a pregnant person? No, this is just battery.
Yeah,
Hold on. You want to talk to your attorney before you say anything out loud? No, that's a CF case too. Can the state advise what's the charge in 3209?
So you were on.
Aggravated battery on a pregnant person.
All right, so that, he was on pretrial release, got arrested for a new domestic battery, which is a misdemeanor. That's what violated that. Yes, I'm revoking 21 CF 5103.
Well, Mr. Payne is arguing that they're derived from the same facts.
I don't know that. I have two different case numbers.
it's from the,
Can the state confirm that? I have two different case numbers. And they're vastly different case numbers.
It is the same victim, Your Honor, but it appears as though Mr. What's his name?
Will the
Mr. Payne.
Will the court entertain any comment from Mr. Payne?
You can say anything you want, Mr. Payne, but everything you say is being recorded and can be used against you later. Do you understand that?
it's understandable.
All right, raise your right hand to be sworn, sir.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
All right, go ahead.
I was asking to be granted a bond and to be put back on the conditions of no contact. I can't really approach anything until I go to trial for it. I just asked to be granted another bond and put back on the conditions of no contact. I really can't really say anything too much until we go to court about it in November.
I can't hear you. Get closer to the microphone.
I said I do ask to be granted a bond and put back on the conditions of no contact. I kind of really can't approach anything until I go to trial in November.
So what I'm trying to determine, though, is if you have three different batteries on the same victim.
I actually don't, ma'am. That's why I say it's kind of hard because I have to approach it in November. I have audio and video evidence of proof.
I'm not asking you to defend yourself against the charges. I'm just saying I'm trying to determine what the charges are. That's why I'm asking the state. Because you don't need to tell me anything because that could incriminate you.
I understand. Okay, so the warrant came about after I was put on pretrial release.
Right.
And it came out of nowhere, which is why the judge gave me the first bond. And then the situation happened in Seminole County, which they gave me a bond also, and I bonded out. But because of my
Is the domestic battery on August 17th in Seminole?
yes, and I had bonded out on that, but I was held because of the warrant that came from here. And that's why I just asked to be granted a bond so I could and put back on the conditions of no contact, so I could also go meet up with my attorney and stuff and my public defender, Brooke Tharp.
All right, let me ask the state. Have you been able to track down these two ag bats?
They do appear, okay. One happened March 12th, the other happened March 18th. In 21 CF 3209, on March 19th, he was given conditional release, 0 bond. In the other case, he missed a court date, and so a capias was issued. It is the same victim, as I said, Your Honor.
But we can't see the battery from August 17th because that's in Seminole. Do you have, it says the Longwood Police Department arrest report is attached. Does anybody have that? Because it's obviously not attached to what I have. Do you have it, Rebecca? Longwood?
I just asked to be.
So the only thing I need to know is 21 CF 5103. What's the bonded date on that? Arrested and bonded?
Actually, if that's the report you're talking about.
No, it's not.
That's not the report you're talking about?
But you have arrest date and bonded date on that?
Just a moment, Your Honor.
I'm sorry? Bonded? Thank you. And then oh, that's this one. Okay. Do you have the other one too? The 3209?
Mm-hmm, I can print it.
No, it's two different incidents. Mhm. Your Honor, according to the information, 21 CF 3209 occurred on March 18th. The information for 21 CF 5103 indicates that the incident happened February 8th, 2021.
Thank you. All right. Thank you all. At this time, I'm also revoking your bond at 21 CF 5103. So you need to have your attorney file a motion in front of the trial judge for both of those cases. Good luck, sir.
Email them today, okay?
There's no bond on the capias anyway. I mean, on the warrant. And then that one I revoked. Do you need these or no?
Bonded, Your Honor.
All right. 21 CF 4113, I'll appoint your office, Mr. Brantz. I find his refusal a willing waiver of his appearance today. It's a capias, I'll stay the bond at $1,000. No contact with a victim, co-defendant, witness, no return to the scene, do not possess weapons or firearms. 20 CF 558, it's also a capias. I'll stay the bond at none. I'll appoint your office. And again, I find his refusal a willing waiver of his appearance in court. Please tell me your name.
Bobby Rivera.
A warrant was issued for your arrest, charging you with aggravated animal cruelty. Another judge has already found probable cause. This is 21 CF 11678. I'll appoint an attorney to represent you. Does the state wish to be heard on bond?
No, Your Honor.
Does the defense?
Reasonable bond is requested, Your Honor.
Your bond is $50,000. You can't possess or have contact with any animal at all. Do you understand? You have to answer out loud. You can't have contact with the victim in this case. Do you understand what no contact means?
Yes.
You can't possess a weapon, firearm, or ammunition. You can have no contact with any co-defendant in this case or any witness. You can't return to 1501 Selma Avenue. Do you understand?
I can.
You cannot. Do you live there? Is that a house?
Yes, it's a mobile home.
Your Honor, can I approach? Maybe-
Yes. right, I'm gonna strike that. He's allowed to return to his home. I'm done.
Is medical, Your Honor?
21 CF 11672. Mr. Brandt, I'm going to appoint your office.
Waive the appearance, Your Honor.
All right, there is probable cause here. I'll stay the bonds, 150 on counts 1 and 2, 100,000 on count 3. Can't have contact with any known drug dealers or any co-defendants, can't possess or consume any controlled substance without a valid prescription. Can't possess a weapon, firearm, or ammunition. Please tell me your name.
Ray Jerome Styles.
In 21 CT 5960, you're here charged with no valid driver's license. I'm going to appoint an attorney to represent you. Excuse me. There is probable cause. Your bond is $500. You can't drive without a valid Florida license. And then in 21 CF 11649, you're here charged with grand theft of a motor vehicle. Again, I'm going to appoint an attorney to represent you in this case. There is probable cause. Your bond is $1,000. You can have no contact with any victim or witness in this case. You can't return to the scene. And that's all. Good luck, sir.
Just a moment to confer, Your Honor.
Please tell me your name.
Sean Thomas.
A warrant was issued for your arrest in 21 CF 11580, charging you with burglary of an unoccupied dwelling, criminal mischief. Another judge has already found probable cause. I'll appoint an attorney to represent you. Do you have a question, sir?
My baby mom went down to the clerk of court today, and in the clerk of court, they sent paperwork showing that this is the residence where I'm at. They sent it to the, I guess to you or this morning, showing proof of my residence that I stayed there.
Oh, you mean at the place where you're alleged to have burgled? So that's a defense that you're going to have to raise in front of the trial judge. We're not going to do an evidentiary hearing today. Can you give him, on your piece of paper, does it also have the address for the public defender's office?
It does.
So, because, let me tell you what's happening is, the state of Florida is prosecuting you, so you want that evidence to get to the state first, not the judge.
Not to be too,
Go ahead.
all I was saying was, all this is just like a family issue or something like that, but I know I'm supposed to say too much, but.
Well, you can say anything you want, but everything you're saying right now is being recorded, and the state can use it against you later.
All I'm just saying is that it's just a family issue going on, you know, and then I have stayed at that residence. That's why I got my big mom to send proof of.
Listen, you may have great defenses. I'm not saying you don't. I'm not telling you you're guilty of this. I don't even know if the state's gonna file the charges. All this is a probable cause determination, and because it was a warrant, another judge has already found probable cause. All that means is there's cause to believe you probably did this. It does not mean you're guilty, and the state has to prove it beyond all reasonable doubt. So we're not there yet, okay? But for purposes of today, there is probable cause. So I can't dismiss the warrant or tell the state to drop it. That's up to the state of Florida. Let me look at something really fast. Did the state file an information in 21 CF 7760? What I want to know is if you can tell me the address of that.
No, we haven't filed charges yet, Your Honor, in one moment.
It might be the same address. I think we're going to start seeing a lot of these. Aggravated assault with a weapon. Do you have the police report from that one, Rebecca? The out on bond case?
It looks as though it is 200 North Ivy Lane, Your Honor.
Oh, that's a different place. Never mind. All right. Did I do all the bond conditions in that one? That one's done? Okay. Because now I have to address your out on bond case, 21 CF 7760. It looks like you're out on bond for burglary of a structure, aggravated assault with a deadly weapon. Mr. Brands, your office represents him on those charges. They're very similar charges to the current, only more violent. And I'm looking at his history. I see 1 prior failure to appear, 14 felonies and 7 misdemeanors. Last conviction in 2018.
Yes, Your Honor. Mr. Thomas has been working with our office, and he's informed me that the alleged victim has also been cooperating with our office in resolving these issues. So I would just have you, if you are inclined to revoke, just have you set a higher monetary bond.
What says the state?
I would object, Your Honor. As you mentioned, it's a violent offense. He has violent offenses, and again, he is accused of breaking into a home and causing damage, Your Honor.
Yeah, I think, Mr. Thomas, at this point, I'm going to revoke that bond. You need to talk to your attorney right away so that they can file a motion in front of the trial judge. Yes, sir, go ahead.
She just went down, because she just went down the date and said that, and wrote the paper saying that she didn't want to, like, press charges or none of that, because it's a family situation. You know, I got injured and stuff about this situation. It's just a family situation going on now. And and her mom, she said that she went down the other day and filed and said that she won't do no type of, no further continuance or none of that now. I mean, I understand how I'm just trying to get out.
I know. What you're going to need to do is have your attorney file a motion in front of the trial judge. They can call witnesses, they can talk to the state of Florida, but they're going to have to do that in this case.
So I can't get out?
Not today. No, sir.
Your Honor, what's the bond on the current case?
I stayed them at $3,500 and $1,000. No victim contact. Do not return to apartment complex located at 5477 Timberleaf Boulevard. No witness contact either. Good luck, sir.
So what I have to do is just get the
Call that phone number and ask to speak to your attorney.
Talk to him about that.
Please tell me your name.
Alan Turner.
21 CF 11652. You're here charged with grand theft of a motor vehicle. At this time, I'm going to appoint an attorney to represent you. There is probable cause in this case. Your bond is $1,000. You can have no contact with the victim or any witness. Do you understand?
No.
Good luck.
On the microphone, she gave me
21 CF 11669. Mr. Brands, I'm going to appoint your office.
We'll waive the appearance, Your Honor.
All right. There's probable cause. I'll stay the bonds at $150,000 and $100,000. No contact with any known drug dealers, not possess or consume any controlled substance, no weapons, firearms, or ammunition, no co-defendant contact. Good afternoon, Counselor. Go ahead.
Good afternoon, Your Honor. James Smith on behalf of Mr. Brian Noel Velasquez Rodriguez.
Is that your name, sir? Yes. All right, thank you. This is 21 CF 11681. You're here charged with sale or delivery of fentanyl and unlawful use of a two-way communication device. Counselor, did you wish to be heard on that?
With regard to the issue of probable cause, no, Your Honor.
Okay, I agree. I do think there is probable cause in this case. I reviewed the affidavit before court. Did you wish to be heard on bond?
Yes, Your Honor. With regard to the bonds, my understanding that right now, on top count, there's a bond of $150,000. And then with regard to the count concerning the unlawful use of a two-way communication device, it's $150. I would ask that the court consider reducing that. I understand the serious nature of the allegations. However, my client is a working man and is simply not able to afford that bond amount. And I've also communicated with his family members. The most that they would be able to come up with for purposes of bond would be $5,000.
Does the state have any reason for why on the sale or delivery, it's $150,000? That's not what we typically see. We typically see $15,000. I don't know if the law enforcement officer made a mistake or if there was a reason that I'm missing.
That was my thought, Your Honor. When I first looked at that, I thought maybe they had fat fingers like I do and put an extra zero on that.
Well, so I was wondering if I'm missing something or, because I read the facts and it doesn't seem, I don't see a lot of aggravators. I'm not sure if it's a mistake.
Your Honor, based on his history and that he qualifies for PTI, I would say that it's a mistake.
All right, does the state object to the defense request of $5,000 on count one?
No objection.
All right, I'll do that then. I'll set your bond at $5,000 on count one, $150 on count two. You can't possess or consume any controlled substance without a valid prescription. You're going to be subject to random drug screens, and you can't have contact with any known drug dealers. Do you understand?
Yes, ma'am.
All right, good luck, sir. Thank you,
Your Honor.
counselor.
All right, that's all I have. May I be excused?
Yes, have a nice day and a nice weekend.
Thank you.
Interpreter cases?
John, if you get the,
I'm ready.
Good afternoon, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have been previously sworn.
Good afternoon. Please connect with the headset.
Certainly, Your Honor. Allow me just a moment to confirm.
Yeah, perfect.
Your Honor, the interpreter can confirm the defendant is able to hear through the headsets.
Please tell me your name.
Hugo Rodriguez Reyes.
Hugo Rodriguez Reyes.
21 CF 11677. I think. Is that right? Is that case number right? All right. Sir, you're here charged with lewd or lascivious molestation on a victim under 12 years of age. There is probable cause. I'll appoint an attorney to represent you. Does the state wish to be heard on bond?
Yes, Your Honor, the offense is punishable by life. I would ask defendant Patel no bond.
Argument from the defense, Your Honor, pending an Arthur hearing with his attorney.
I'll do that. At this time, sir, you'll have no bond. But even while in custody, you can have no contact with the victim. Do you understand what no contact means?
Sí, entiendo.
Yes, I understand.
Does he have another pending case
Seen on that.
for the other charge? It's the exact same charge, though?
Mhm.
All right, thank you. I'm done.
And Your Honor, the interpreter can confirm that case number. Your Honor said 21 CF 116677.
11677.
Thank you, Your Honor. I thought I had an extra digit in there. I appreciate it.
Today I've had trouble reading the case numbers, so you never know. Please tell me your name.
William Geraldo Rivera Rodríguez.
Julian Riveldo. I'm sorry, Your Honor.
William Geraldo Rivera Rodríguez.
William Geraldo Rivera Rodriguez.
Thank you. 21 CF 11656. Sir, you're here charged with armed burglary of a dwelling, occupied dwelling, resisting an officer with violence, and aggravated battery on a law enforcement officer. I'm going to appoint an attorney to represent you. There is probable cause here. Does the state wish to be heard on bond?
Yes, Your Honor. Count 1 is punishable by life. I would ask defendant be held, no bond.
I will do that at this time, sir. Sir, you'll have no bond on count 1.
Dice cuando de mi declaración, ¿sí?
Clarification, Your Honor.
Ok, no tienen ninguna prueba en mi contra. No hay ningún force de puerta ni ventana en mi contra, ni nada agravado.
There's no proof against me. There's no proof that any windows or doors were forced open. There's no recording that shows me doing anything.
Ajá.
Yeah, sir,
No hay agresión, no hay agresión entre policías porque el policía me atacó primero y tengo el derecho de defenderme.
There is no battery against an officer. The officer attacked me first, and I have every right to defend myself.
Sir, there is probable cause to support these charges. And no one in the United States of America has the right to choke a police officer who's in the lawful execution of a legal duty. That's what's alleged in this probable cause affidavit.
Ilegal. Es ilegal.
Sir, it's in your best interest to listen to what I have to say. Everything you say today is being recorded and can be used against you later. Do you understand that?
Sí, estoy consciente.
Yes, I'm aware.
This is not a jury trial. We're not having an evidentiary hearing. I'm just telling you that there's probable cause based on the probable cause affidavit.
Okay.
If you think you have some defenses to this charge, you'll want to talk to your attorney about them and raise them at a later stage.
Ok, y entonces podría demandarlo al que me juzgue, ¿verdad?
Okay, and then I can sue those individuals, correct?
I can't give you legal advice,
No,
so your attorney can do that.
esas son mis palabras. Ok.
So you'll have no bond on count 1. However, even while in custody, you can have no contact with the victim. Your bond on count 2 will be $5,000. Your bond on count 3 will be $25,000. You can't possess a weapon, firearm, or ammunition. You can't return to the scene for any reason. All right, good luck, sir.
Igual.
The same.
I believe that's all we have for the interpreter at this time.
Thank you, Your Honor. Have a good afternoon.
Thank you. Anything else from either party before court is adjourned for the day?
Nothing from the state, Your Honor.
None from the defense, Your Honor.
All right, we'll be adjourned.